Good morning, sir. I'm Pen Hendrix Arquerona, and today I'll discuss what I learned in the criminal procedure. It starts on Rule 114, which is based to Rule 118. So first, Rule 114, bail. Bail is the security provided for the release of the person in the custody in the custody of the law, provided for by him or by his bondsman to guarantee the bail of the person who in the custody. The person who in the custody, the appearance is required or needed in any court under the conditions specified there. The right to bail is applicable only to one who under in the custody of the law. For example, the person was convicted and the penalty is imprisonment was exceeding 6 years above, or conviction of reclusion temporal or reclusion perpetua, he or she cannot be granted by a bail, or he or she not applicable to give a bail. The judge cannot be granted a bail because a hearing to be held first, and when a grant of bail is discretionary. Number one, the condition and requirements of the bail. Number one is the accused should have appear in the court. Number two, if the accused did not appear to the court or in its trial without justification, shall the case may proceed is called absentia. Number three is the bondsman need to surrender the accused to the court for the execution of the final judgment. The next is the right to travel is also restricted by the grant and bail, because the court is prohibited for a person released on bail from leaving the country because the trial was not done. In bail have four forms of bail. Number one is the property bond, corporate security, cash bail bond. The next is recognizance. The next is the summary hearing. It means the hearing must be speedy, or the method of proceeding the evidence of the guilt. When is bail is cancelled? The bail is cancelled if the accused was surrender the proof of his death, the acquittal of the accused, and the dismissal of the case. And the next rule is Rule 115, the rights of the accused. The rights of the accused should have right to counsel, rights against self-incrimination, right to information, right to speedy and public trial, and right to defense himself, right to appeal in the court if applicable, and another right of the accused are the right to bail and the right against excessive fines. and the accused, what happened if the right the accused is prohibited? The accused can ask for new a trial in the court, or the right to the speedy trial. The Republic Act 8493, it is called Speedy Trial Act of 1998. It means the accused can have a public trial, and the accused have the right to appeal. The next is Rule 116, arraignment. Arraignment is also defined as the reading of the criminal complaint or the information to the defendant, and it is reading of the charge against of the accused in court and declaration of the latter, if whether he or she guilty or not guilty. The purpose of arraignment are to fix the identity of the accused, to inform him to charge against him, to give him a opportunity to plead, and when a accused cannot go to the court, and his friends go there, it is called arraignment proxy or arraignment absentia. If there's no arraignment, the accused cannot be convicted, and this is true even there was a new trial for it. Next is the plea bargaining, is the process where the accused, the prosecutor in a criminal case was work mutually satisfactory disposition, and plea bargaining is not allowed for violation of the Republic Act 9165 or Comprehensive Dangerous Drugs Act of 2002. The next is Rule 117, motion to quash. Motion to quash is a formal motion filed by the accused before the arraignment. The displaces information means it is an information that charge more than one offense or habitual delinquency. Modes of delinquency, the modes are the criminal liability. Number 1 is the absolute pardon, prescription of crime, prescription of penalty. So, what is double jeopardy? The rule of jeopardy means that when any person was charged, when an offense in the case was terminated either by acquittal or conviction. What is noli proseq? What is noli proseq? It is a written argument presented by prosecutor stating that he does not believe into the evidence to obtain a conviction of the accused. The next is Rule 118, pre-trial. Pre-trial is the stage of the court proceeding before the trial. The importance of pre-trial is allows the parties to explore the responsibility of the criminal cases cognizable by RTC Metropolitan, City Bayan, or Municipal Trial Court. After arraignment, 30 days before arraignment, 30 days jurisdiction, and the Speedy Trial Act or RA 8943 can be used in pre-trial. The effect of non-appearance of the parties of the lawyers at pre-trial, the court may impose improper sanction of penalty. Ayun, sir. Thank you po.